In a contract over securities with the New York choice of law provision, does New York law or the issuing jurisdiction's law apply to determine whether it's valid or not? To find out, you have to read Petroleos de Venezuela versus MUFG Bank, but it's 23 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of Petroleos de Venezuela versus MUFG Union Bank. The citation for this case is 2024 New York Slip Opinion 00851, published by the New York Court of Appeals on February 20th of 2024. The issue in this case is choice of laws and whether New York law applies or the issuing jurisdiction's law applies to determine whether a secured note is valid or not. To understand and appreciate the context of this case, I think some helpful background is that basically a note or a bond is a loan being issued by a lender or by a borrower. And it basically says, I'm going to pay you back the amount of money you're giving me plus interest. And there are two kinds of important notes. There's an unsecured note and a secured note. An unsecured note basically is not backed by collateral. You're saying, I want to borrow this money and I'll pay you back. And if I fail to repay, you can sue me. That's an unsecured note. But a secured note is backed by collateral. It's backed by a thing that's worth as much or more than the loan itself. So if you take out a home mortgage, the collateral is the house. So if you fail to repay it, they can take the house. If you get a car loan, the collateral is the car. The other thing you have to understand is that a choice of law is contracting parties can decide what law is going to apply to resolve any disputes between them. And the last thing you have to understand is that in Venezuela, Article 150 of the Venezuelan Constitution says that oil is a natural resource and it's important to national security of Venezuela. And so any deals involving the sale of oil have to be approved by the National Assembly, which is like their Congress. Okay? So what are the facts in this case? The facts are that there's multiple, basically the plaintiffs in this case are Petroleos de Venezuela, which is PDVSA. People call it PDVSA in this case. PDVSA is how it's described in the oral argument. It's an oil company wholly owned by Venezuela, by the Venezuelan government. Petroleo is incorporated in Venezuela, and it's a subsidiary of PDVSA. And lastly, PDV Holdings is a Delaware company. It's an American company, but it's a subsidiary of PDVSA with its principal place of business in Houston, Texas. And that's what owns Citgo. Citgo is the oil company of Venezuelan oil. It markets oil and gas in America. So an MUFG Bank is the respondent, the defendant in this case. So Petroleos, basically, PDVSA, that Venezuelan company, in 2007 issued $3 billion of unsecured notes, of loans, to try to raise capital that would be that would be paid back by 2017 in 10 years. In 2010 and 2011, they issued more of these notes, unsecured notes, for a total of $6.15 billion of obligations that PDVSA had to repay in 2017. But in 2016, as the date for the notes to come due approached, they realized that they wouldn't have the money to pay back these loans, and they would have to default. So in 2016, President of Venezuela, Nicolas Maduro, declared a state of emergency, granted himself the authority to execute public interest contracts unilaterally, which is, remember, against Article 150 of the Constitution of Venezuela, and basically said he was going to make new contracts, try to resolve this issue, where instead of Venezuela declaring going default. The National Assembly didn't like this because this was their authority, and they passed resolutions saying Nicolas Maduro didn't have this authority, they wouldn't honor any contracts. But despite this, PDVSA's board of directors approved a bond exchange to avoid default. So basically in this bond exchange, they said anyone who has these 2017 bonds, exchange them for 2020 bonds, which are going to be secured by Citgo stock. So instead of people coming in 2017 and having to get paid back, they said anyone who wants to exchange their 2017 bonds for a secured note, secured by Citgo stock, 50.1%, so controlling interest in Citgo, please exchange it, and then we have 3 more years to build up our income to be able to pay back these notes so we don't default. It turns out that around almost 40% of the owners of these 2017 notes took the exchange, which was worth over $3 billion. or approximately $2.8 billion, which would be worth $3.3 billion in 2020. In 2018, Maduro was reelected, but this was contested. And basically, when it came time to make these payments in 2019, PDVSA defaulted and said, we're not going to make any more payments, and we're not going to honor in 2020 these promises we made in these secured notes. And they filed an action in federal court in Southern District of New York to declare void and invalid these secured notes issued by Maduro's government because they were not backed by the assembly, and therefore they were not valid constitutionally under Article 150. The defendants counterclaim for a declaration that they were valid, and now and when it goes to the they move for summary judgment. The defendants do. The U.S. District Court for Southern District grants the defendant's motion, says that the notes are valid and enforceable. The plaintiffs appeal to the Second Circuit Court of Appeals. They don't know the answer, so they send it to the Court of Appeals of New York and say, what would you guys decide? Because we're having to decide New York law. So New York law reformulates the question submitted to them and says this, reformulates it like this. Given the presence of the New York choice of law clause in the documents of this bond exchange, is the validity of these bonds governed by New York law, or is it governed by Venezuelan law? And the answer here is it's governed by Venezuelan law. The holding here is that matters that go to the validity of a security, in here it's the Venezuelan 2020 notes, secured notes, are governed by the law of Venezuela, the local law of the issuer's jurisdiction. Why? Because even though it's a New York law contract, they've chosen New York law to govern the transaction. There's like a chain of citations here. They say New York law controls, apart from Section 5-1401, which says the things that don't apply include 1-301 of the Uniform Commercial Code, and 1-301 of the Uniform Commercial Code says what doesn't apply is Section 8-110, which is validity of a security. So if you follow that whole chain, which the Court of Appeals does, they say the issuer of a security must abide by the validity requirements of its own jurisdiction. So when it comes to the validity of a security, you have to go check the issuer's jurisdiction. But everything else is New York law. So, and they distinguish. They say, what does that mean? Well, the validity is determined by Venezuela here, but that's different than enforceability. It's different than the consequences of invalidity. Those are going to be governed by New York law. So they send it back to the federal court saying validity is determined by Venezuelan law, but that's not the end of the question. New York law applies to everything else apart from validity. So if you're a holder in due course, if you bought this security from somebody else and you didn't realize there's a problem, well, you might still have the ability to enforce the agreement. You might still have the ability to get some kind of relief, might be able to get paid back. But the validity question, that narrow question, will be determined by Venezuelan law. And that's the case of PDVSA, Petróleos de Venezuela versus MUFG Bank. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.